To end this session, I want to bring us a little bit nearer home, and I'm going to explore a number of aspects of Welsh history with you. I'm going to look at an early Welsh lawmaker who codified the laws, Howells or Howells, depending on your pronunciation. And where you may be based in Wales. The Laws in Wales Act, often called the Acts of Union with Wales, when Wales was not Wales, how the use of Welsh as a language has been subject to legislative control, and then look at some other miscellaneous examples which help sort of explore the richness of what was a legal system. So there was a group of legal historians in the 1960s who wrote widely about medieval Welsh law and the system. And there are a number of academics who do so today, but it has been until devolution probably regarded as quite a niche subject. But as the powers of the Senedd have grown, there's been an increasing acknowledgement of prior Welsh legal history, in particular those early codified laws. So what I'm going to do today is just provide a really brief overview. I could spend days and days talking to you about various Welsh laws, Welsh cases, the influence of society, the strong influence of oral history in retaining those stories, influences of religion, of politics, and of the language itself. Now, one of the things when researching Welsh history is there are some challenges, because there are some areas such as crime and punishment which are well documented, and some of the large estates, but there are many others that are less so, because of the use of Welsh being made illegal in public documents for a number of centuries. And it is important to recognise that in Wales, oral as well as recorded histories have played a role in memory and in historical perspectives. And there are a number of projects, and have been a number of projects from the 1950s onwards, which recorded some of those oral Welsh histories. Now, I want to talk a little bit about Hywel Dda, because this was a very early functioning legal system at the time of the Anglo-Saxons in England, and indeed there were treaties between the Welsh rulers of the time and the Anglo-Saxon rulers. And the legal system was actually based on a number of laws that had been codified in the mid-10th century. And the laws are said to be just, compassionate, and there are a number of the laws which would be recognised today, such as compensation, restitution, as opposed to more severe or harsh punishments. Now, for a historian, there aren't any copies of the original codified laws. There are early copies that date from the 12th century onwards, and those manuscripts are in Latin and Welsh. And in the not too past future, there was the National Library in Wales bought one of the books, and it's freely available to view online. We're not sure how the laws were codified. From the tales that exist and the few documents that exist, it's thought that they held a convention in a place called Whitland in West Wales, where the cantrefs were invited. They looked at existing law and then codified it, keeping laws that were of value and setting aside outdated, inappropriate laws, or writing new laws to replace them. And in a similar way, the Senedd at the moment is looking at codifying the laws within modern Wales. So, for example, laws on ancient buildings, or the law on renting properties has just been updated and upgraded so that it is accessible. And this accessibleness has been a key theme that that has come through, as well as transparency. Now, there are about 40 law books, and these illustrations are examples of some of them. And the books are very well used, and so it's thought that these were ones that would have been used by lawyers themselves rather than having been in some wealthy library housed in a castle or in a monastery. And these illustrations are rare in a Welsh manuscript of this age. And the laws covered the king, the officers of the court, but they also cover society, kindred and status, animals, crimes, tort, property, contract, and the laws of women. And they see the people living in Wales at that time as being in three categories: the king, free landowners, and the peasantry. And there was also this category of people from outside Wales who had settled in Wales. Now, Wales, particularly West Wales, was quite remote at this time, and 2 pilgrimages to St David's at that time was equivalent to a pilgrimage to Rome, which helps illustrate how remote perhaps some of the areas were. And I just wanted to share with you some examples of the laws and the punishments used, because these can be very useful with students in sort of discussing and looking at how some laws in medieval times could actually be far more advanced than some of the laws in England in Victorian times. So no idea of capital punishment. It's about payments, clemency for somebody who'd stolen food if they could prove that they'd been begging, and value was placed on all kinds of property, you know, from kittens on upwards. And the laws that in particular scandalised both the Anglo-Saxons and the Normans, and the Archbishop of Canterbury was very critical of them, were laws that regarded illegitimate and legitimate children as equal. And that was one area which was particularly not well regarded by neighbouring countries. But, you know, the laws were in many aspects ahead of their time. For women's rights, for example, you know, marriage was a contract, divorce could occur after 7 years of marriage. Then there was a list of who was entitled to what half of the property, and, you know, common consent was provided for divorce. So a very different system, a much more open system than operated at that time in either Anglo-Saxon England or later in Norman England. And these systems continued until the 13th century, and they became a real symbol in the struggles with England. And following conquest by Edward I, Wales began to be it was a slow erosion of those very forward-thinking laws. Firstly, criminal law went, then civil law. There were changes due to church influence, so illegitimate children were no longer able to claim inheritance. And it's really interesting that there are lots of comments appearing from 2015 onwards, which kind of shows the re-emergence of debates around this system about the laws containing elements of mercy, common sense and respect for women and children that were absent from the law of England until recent times. So really interesting period of history, particularly in terms of legal history, and looking for comparisons. And they've been held dear within the culture and the history of Wales. And the original home of the Welsh Assembly, the Senedd, now the Welsh Parliament, was T. Howell, as the Assembly chamber was also named after him. But Henry VIII created significant change. Now, for somebody who based his ancestry on tracing a long Welsh heritage, this was quite interesting, and there are a lot of myths and stories around what are often actually referred to as the Acts of Union, but actually are the Laws in Wales Acts, which annexed Wales. And the language used is quite interesting. And with students, we do try and use some original material to engage them with the different types of language that are used. Now, the emphasis here is the emphasis that I have chosen, but you can see, you know, the natural mother tongue is being seen as English. You know, the king is calling his subjects rude and ignorant. They're creating discord, variance, debate, division, murmur, and sedition. And that he wants to extinguish all, and the word sinister usages and customs are used, and that Wales is going to be incorporated, united, and annexed with this realm of England. Now, remember, Henry VIII claimed to be King of Ireland and of France at this time as well. And it says that all persons shall enjoy all liberty as other subjects. But that liberty didn't extend to being able to continue to use existing Welsh laws or to use Welsh in official business purposes. So it's quite interesting using this sort of extract from the beginning of the 1535 Act to engage students with where language comes from, where it's being used, and so on. So you see the words dominion, principality being used here. But it also led to some others, because Section 3 of the Wales and Berwick-upon-Tweed Act provided that references in Acts of Parliament to England automatically included references to Wales and Berwick-upon-Tweed. And this continued until 1967. And there's an image there of the Encyclopedia Britannica, where you can see at the bottom, there's in capitals Wales, and it just simply says "See England." And this is a legacy of that 1746 Act, which was not repealed until 1967. And the use of Welsh is something that has been of particular debate. And I can remember protests in support of the language as a child. And the Welsh language was prohibited in public office following the Laws in Wales Acts. And there were a number of acts which talked about the use of Welsh. So the 1549 Act of Uniformity said all public acts of worship were to be conducted in English. But Elizabeth I then went on to say that churches could have Welsh versions of the Book of Common Prayer and the Bible. And a subsequent English parliamentary report notes that the Welsh language is a vast drawback to Wales and a manifold barrier to the moral progress and commercial prosperity of the people. You know, thinking about this idea that in Wales at the time of the early medieval laws, there was no distinction between illegitimate and legitimate children, and that women had rights and had a say, for example, in their marriage. And this was still being frowned upon many centuries later. Then we have the Justice Acts of the 1730s, which ostensibly were to overcome the archaic use of Latin and French terminology in some legal proceedings, but it also criminalised the use of native languages in court hearings throughout Britain and Ireland. And in schools, there's the infamous Welsh knot, which is sometimes portrayed in films. And these were signs hung around the necks of children, or sort of wooden poles that they had to hold for children who spoke Welsh. And as you know, they'd hold that as a badge of shame, and then immediately a colleague spoke Welsh, it would be passed to them. And that is illustrated in a number of films, including films made in the 1940s. And that practice continued until up to around the First World War. And the picture there with the WN is one that's on display in what was the Welsh Folk Museum at St Fagans, is now the National Museum of Wales. We then move on a number of centuries, and in 1942 the Welsh Courts Act enabled the use of Welsh in court proceedings in certain circumstances, for example with Welsh speakers with a poor level of spoken English. Now, for the population of Wales who only spoke Welsh, from the time of Henry VIII effectively to the Welsh Courts Act, they hadn't been able to use their language in court, and they would have had to have relied on somebody translating for them. But despite the 1942 Act, the entirety of the proceedings would generally be held in English, and there are some illustrations of cases in the 1940s around this, where defendants were being charged for fees for translation of their evidence into English, so it could be presented in the court. And some of these cases involved the compulsory purchase of land for the purposes of training the army. And I won't go into a number of those cases, but they were infamous in their time. We then move on to 1967 with the Welsh Language Act, which recognised in principle the status under British law, but courts had to still be notified in advance, and legislation still wouldn't have been translated into Welsh. So again, for Welsh speakers, they're not being put on an equal footing. We then had a 1993 Welsh Language Act, which established sort of Welsh on an equal footing in the law courts with English, and obviously since the establishment of what was originally the Welsh Assembly is now the Senedd, law legislation is bilingual, and courts and so on, and legal work is conducted in Welsh. And there's a picture there of Section 4 of the 1967 Welsh Language Act. And finally, I just wanted to sort of think about some examples and reflections. And one of the speakers earlier this morning touched upon, the way in which the history of the United Kingdom is presented. And, you often see statements that since the Glorious Revolution, England has never been invaded, or the UK has never been invaded. But, things like the Battle of Fishguard is often not taught. This took place in 1797 when the French government devised a plan to invade England, and they chose 3 sites, one of which was in Ireland, and the one where they landed successfully was near Fishguard in Pembrokeshire. They caused some damage to a local church, and eventually it all ended with surrender on Goodwick Sands. And there is a picture of a tapestry which has been dealt to celebrate and recognise that invasion. And then on the right, you've got a gravestone that's still in a local graveyard that talks about Gemma Nichols, who was a Welsh heroine. She went out with a pitchfork to meet the French invaders, and she locked some of them in the church, ready, waiting for the army to come from nearby Carmarthen and Haverford West. Well, when I say nearby, they're 60 or so, 50 miles apart. We also then have the Newport Rising. A lot is made of the Chartist risings in places like Manchester, but the Newport Rising is very rarely reported, but it is said to be the scene of the worst state-sponsored killing in Britain. At least 22 men have been named, but it's thought that more were killed at the time, and they were marching for their rights to fair treatment in employment, rights to vote, and one of their leaders, Zephaniah Williams, actually there are court records of what happened, and he was initially condemned to death, but was commuted to life imprisonment. He was transported to what is now modern day Tasmania, although he was later pardoned. Also little reported on, outside of Wales are things like the Rebecca riots, which occurred in the countryside, protesting against higher taxes. And in more recent times, in the 1940s and the 1960s, you had the closure and uprooting of communities for army training from rural lands, which meant not just uprooting the lives of farmers, but it also meant from those rural communities the loss of the Welsh language. And in one of the training bases in Pembrokeshire, the family stayed near their farm, and when the Ministry of Defence put it up for sale a number of years ago, they tried to rebuy it, but because they'd been promised the farm would be returned to them, but they couldn't afford the asking price of several £million. And then we have the flooding of a number of Welsh valleys, and you can see a picture on the right-hand side of the screen, where Liverpool City Council needed to provide water and chose to do so in parts of rural Wales, but to avoid some of the challenges, they didn't go for local planning permission. They sponsored a bill in what was then the UK Parliament, so there couldn't be local opposition or even local political opposition, because the bill went through the UK Parliament and it was approved, although 35 of 36 MPs from Wales voted against it. Now, Liverpool City Council have since issued apologies, but that's just one example of Capel Celyn that was flooded, and we also there are more recent examples, for example, of Google to celebrate March the 1st, St. David's Day, of using an image of the castle of Edward I, and there is the naming of the Prince of Wales, which remains contentious. So when I was taught law, I was taught about the English legal system, despite the fact that that covered the law of England and Wales, and we have an increasing growth of Welsh legislation. But by bringing in, for example, the medieval system of Wales, it enables us to make comparisons, to challenge the accepted norms that can be sort of transformational in understanding that laws from earlier societies can actually be seen as more just than maybe laws from Victorian society. It enables us to be more inclusive, to recognise the complexity and the different legal histories, and that enables us to engage students with the law in their locality and also with their skills development, and it enables that recognition of different approaches, differing legal cultures, and the richness and opportunities that brings. And I will finish there